where new voices are entering the room and beginning to influence the direction. She has worked with The Hague, in New York City, I think in the ICC, in Human Rights Watch, the international NGO, and across institutions that are fault lines of law, power, and justice. Our guest today, Dr. Kia combines scholarship with practice, holding a doctorate in law and teaching across some of the world's leading institutions while remaining grounded in reality. So when we speak about the future of international law in a world that is looking increasingly lawless, we are not speaking to our guest in the abstract. We are speaking with a person who is very actively engaged in the field of international law. So Doctor, you are most welcome to the Judicial Service Conversation.
Thank you very much, Ellison, Council Ellison, for the opportunity to be here.
I think I've also seen on the space none other than the renowned Uganda's permanent representative to the United Nations, His Excellency Ambassador Adonia Aibai. He's also a doctor. He has a PhD. I can see a friend of mine, Nicholas Opio, who likes talking about PhDs. While he has a PhD, I think he will agree with me that if he called himself His Excellency Ambassador Doctor, he would be misunderstood. The titles being as many as they are, he would be seriously misunderstood. But His Excellency Adonia Aibai has been, and for a long time, our representative of the UN. He's a gentleman who sits at the front line of diplomacy, and he sits where international law meets real-world negotiations. He's also been the chairman of the Nana-Line movement, and he has come here today to enrich our conversation. And so, I don't know what time it is in New York City. The internet here is certainly better than the one there, because there they may be rationing internet on account of they have too many assassins moving around. But you're most welcome, Ambassador Adonia. How are you?
So, thank you for having me.
Okay, thank you for being here. And now, we will soon learn that Alfred here doesn't have any
hate injustice. That is who I am. I am all for equality. My passion is about challenging injustice, inequality, but also engaging in intergenerational learning through teaching and speaking to young people. I love what I do. I think that's the thing that makes me go to sleep at night, because in terms of ego and policy framework, you go to bed knowing, yeah, there's no money in that, but at least you're creating and changing lives of people each and every day. So one thing that I'm now getting interested in is the aspect of international space law, because I think we all see the race to space, what is happening, and you know, the satellite internet. So that is something I'm very interested in, and also looking forward to the committee's new work in aspects of digital technologies and artificial intelligence. You asked the question of what makes me tick. I think for me, it is the realization very quickly, that people make me who I am. So why I say tick is because many people don't come to that realization very quickly, that you are not as bad as in you're not as cool as you think you are, because everything that you achieve is because of people. People believe in you, people make you who you are, people fight to ensure that for your success. And I'm so glad that Ambassador Adonia is in here, and so many people from Ministry of Foreign Affairs. His Excellency knows how intense our first campaign was. And that is when I realized firsthand that teamwork and people make you who you are. So thank you.
Okay, so you're going to be our guest today, but before we delve into the conversation, I want to give an audience to Ambassador Adonia very briefly for about 10 minutes. And Ambassador, first of all, many people know who you are, but still it would be good to know who is Adonia Ayebare, His Excellency Doctor, who is not from West Africa, and what makes you tick. But secondly, Brenda has talked about an election and about a campaign that she had and a committee that she's on. And as a person who has been in diplomatic spaces for a long time, if you could just bring to our audience what exactly we're talking about before we start having this conversation with her, we would greatly appreciate it. So briefly, tell us about the gentleman called His Excellency Dr. Adonia Ayebare, and then about this committee and this election that Brenda, the campaign. I think she spoke about a campaign that was tough. If you could just tell us about that, because as our representative on the UN, you know about these international bodies, and we usually see you leading these campaigns. And also a brief overview of really the mission you're at and the sort of campaigns that you're leading, so that the people, the thousands upon thousands of people who listen to the Judicial Service Conversations, can have a fantastic understanding of this doctor, who has, by the way, a PhD in international law. Over to you, Ado.
Thank you, Edson. Of course, you really introduced me. You've done the introduction. But I mean, I represent Uganda at the United Nations, but there is nothing permanent. Like my title, suggests, I can be recalled tomorrow or after tomorrow. But anyway, let me start by really, thanking you for giving me this opportunity, and for talking about our main guest, Brenda, on how Committee CEDAW is really very, very important. It's at the heart of a very interesting international legal regime that really talks about, the rights of women and children. But how did she get there? How do we do these things? Uganda at the UN does not really carry a lot of weight. We work as Africa and as developing countries. She was really, really, she is a very fantastic, not only legal mind, but, personality. She was endorsed by the African Union, which makes the work easy. Once you are endorsed by the African Union, you have over 50 votes automatically. So that made the elections at the UN a little bit easy, but also competitive, because every region wants to be on the committee. And Africa is always disciplined. We have what we call a clean slate, but other regions bring in a lot of candidates that makes the whole calculation very complicated. Of course, you're elected by the entire UN General Assembly, 193 countries, by secret ballot, and countries promise sometimes and don't deliver. But Brenda was easy to sell because she was a good candidate. What I have learned is that when you are campaigning for good candidates who are qualified, countries listen. I have been really very privileged by campaigning for very brilliant Ugandan candidates at the UN, and mostly lawyers, women lawyers. I have twice campaigned for Julia Sebutinde at the International Court of Justice, where she's serving her last term. Also, Justice Salome Bosa, the International Criminal Court. Justice Margaret Tebulia on the UN Tribunal, and recently Deputy Chief Justice Emeritus Richard Butera, also on the UN Administrative Bureau. Really, to tell you that Uganda has brilliant minds, legal minds, and it's not only does not stop only campaigning for them, but how they do once they are in those positions. It's really, and that's really very, very important. That sets a stage for future lawyers to really campaign and get elected on these international posts, especially tribunals and courts. So they don't only become, participants in international law. They make international law. When you look at the International Court of Justice, which you are all familiar with, International Criminal Court. So we are lucky to really have people in those positions, and really the way they perform also opens doors for the future generation to participate. I'll quickly talk about. The people have been talking about writing arbitraries about international law. International law is not going away. I would want to use the word that it is only adapting under pressure. The system was built after the Second World War, and it has a design problem. It was built really to serve the big powers. Now, when it gets tested on big powers, it gets challenges. What is emerging is more complex, less centralized, and almost chaotic system that we are dealing with. And of course, any legal system or any system is about compliance. Countries, follow rules when convenient, most of the time, especially the big ones. And there is always tension between sovereignty and global norms, which we really experience every day at the UN. Every week, now things that you
Have we lost you?
regional and hello?
I think we had lost you, and maybe just before you go to international law, just very briefly, if you could tell us this thing that Brenda is standing for. Many people who are on her, they will understand the ICC.
CEDAW.
Yes.
Yeah, CEDAW is really a very important committee that deals with that advocates for the rights of women, and she served one term, so she's looking for a second term, and hopefully the last term, because I'm not ready to campaign for her third term. I don't think I'll be there. So it's really it's really feeds into the whole issue about human rights architecture. So that's a specific committee that deals with women rights at the UN, and I think she stands a chance of being re-elected for the second term because of her performance in the first term. So that's what we are up against, and I'm glad you have given her audience to really talk about her vision, and she will tell you about her campaign strategy and how we are doing as a mission, because every Ugandan that campaigns in the UN system goes through my office. Like she said, teamwork is very, very important to make her cross the line. And of course, it's a very expensive venture to campaign. You know, she will tell you that she's always very broke tickets and all that. But it's a commitment, really, and she has passion on what she does on the committee.
Okay, thank you. And then just before you go, maybe the two quick questions. The first one is that question about international law. Somebody had written on X that international law, according to him, our understanding of international law, I think he had said it is I can't get the quote right now, but someone had written that it is simply the law that the righteous cannot enforce and the wicked cannot obey. So it is really what we call bad law. So your comment on the state of international law. And secondly, on a domestic matter, we shall ask you, not Brenda, there is this famous or infamous, I don't know, maybe famous, sovereignty bill. Your views on the sovereignty bill and on the state of international. And why the state of international law is important right now is that we see a certain country that I don't want to mention because we are learning to be diplomatic, that just wakes up and goes and kidnaps a president somewhere else, assassinates another one, blocks international waterways, bombs, promises to annihilate civilization. So what's your view on the state of international law at the moment?
I'll pass on the famous or infamous, sovereignty bill. Of course, I'm here to defend everything Ugandan, but I
think we've lost you.
Really, yeah, I'm back. I keep on getting calls. I'm really happy that there is a debate on the sovereignty bill, and that speaks to our vibrant, democracy. And I think I'm watching from the distance in New York, and I will see how it pans out. But international,
so I think we lost you again.
The system.
I think we lost you again, Ambassador. We lost you when you were telling us how you're in Kamoli on that, and then you are going into the question on international law. If you're just joining us, welcome to the Judicial Service Conversations.
Yes. Once their interests are threatened, then it tests international law, and that speaks to compliance, selective compliance when convenient, and that's a trend we are seeing, and it's going to continue as long as the interest of the big powers in conflict with international law. But also what is emerging is regionalization. You have seen Europe versus the European Union law, Africa through the African Union frameworks, building blocks like ASEAN, because when the international system does not work, international law goes regional. And of course, Brenda, and you talked about technology and others, cyber warfare, artificial intelligence. That's the future. And we haven't even gone there. So international law is evolving. It's not disappearing.
Okay, thank you. Thank you, His Excellency Ambassador Adonia. Everybody? I think we've had it all. International law is evolving. It is not disappearing. And if you are worried about strong people who are not obeying it, don't worry. Once international law gets broken, it goes regional. And so that is where we are. I want to come back to you, Brenda. So we've heard from the ambassador about this thing called CEDAW. And I think you're going to keep telling us. I think you just that is CEDAW, CEDAW, the CEDAW committee. We don't understand what that is. Ambassador has given us a bird's eye view, but now you're the candidate. He's presenting you, and now us we are giving you an audience before the people of the Republic of Uganda, the legal committee, the legal community, and the public at large. And we want to understand this thing you're in called CEDAW. What is it? What does it actually do? And I am here. I am a Ugandan ordinary lawyer. We have a number of ordinary lawyers in this room. Then we also have some extraordinary lawyers in this room, like Joy there. And so we want to know this thing called, what is this CEDAW? Who is CEDAW? They're calling it a committee. Whose committee is it? Why should our ambassador, who has to fight for all our issues, spend time campaigning for you to be on CEDAW? What CEDAW is? Yeah.
Thank you very much, Edison. But you know, it's very hard to speak after the person who works so hard with the whole team at MOFA to put you in this position, because he explained it really, really well. And thank you, Your Excellency, for the explanation. Maybe just to go in detail of what CEDAW is, I'll first start with just the normal day-to-day to relate it to our day-to-day. The simple answer is the reason Joy and I have been to law school, the reason if you have a daughter or a sister or a niece, the reason they've gone to school, the reason they're able to work, the reason they're able to, let's say, drive, is because of the work of the CEDAW committee, but based on the CEDAW convention. So day to day, you know, many times women and girls are not being able to own property. They've not been able to have even a passport or to travel. They're not able to even giving birth safely without having to succumb to death. That's all the work the CEDAW committee does. So just to, in lay terms, for day-to-day people to understand what CEDAW is. So it transforms your day-to-day life for women and girls. But the technical aspect, but also secondly for lay people, for day-to-day, for us to understand before I go into the technical aspects, CEDAW also, you see that we have our constitution, we have legislation in Uganda that's about women and girls' rights, that promotes gender equality, that promotes women peace and security, that promotes women and girls' rights. All that is based on the CEDAW. So that is domestication of the CEDAW convention. So I hope now I have brought it closer to home. I can now go into the technical aspect.
So you're saying that our laws on women's rights, on children's rights, are domesticating international treaty?
Yes. And of course Maputo as well, which is the regional, but because CEDAW is referred to as the International Bill of Rights for Women and Girls, and that is what Uganda has domesticated. So CEDAW, when you talk about the Domestic Violence Act, that is based on CEDAW. When you talk about women and girls have a right to equal participation in decision making or becoming members of parliament, affirmative action that we talk about for education or in parliament, women and girls with disabilities, that is all the work of CEDAW. And of course, regional instruments like Maputo, but yeah.
So CEDAW in full is again?
So I'm going to now give you that. Now, after I've laid that basic understanding for CEDAW, let me now do the technical part for lawyers and other people. So the UN CEDAW committee in full is the United Nations Committee on the Elimination of All Forms of Discrimination Against Women. This committee is based on the CEDAW Convention. The CEDAW Convention is in full, is the Convention on the Elimination of All Forms of Discrimination Against Women. So this CEDAW Convention is referred to as the International Law for Women and Girls' Rights. This treaty, it's a treaty, it's part of international, it is international law for women and girls' rights. What it does, it sets out clearly for state parties what, one, women and girls' rights entail, two, what gender equality is, how state parties should promote women, peace and security, access to justice, how they should be able to promote substantive equality. So that is what the convention has, about 16 provisions that speak to women and girls' rights. So in all they say, the CEDAW Convention calls on state parties to take all measures to eliminate all forms of discrimination against women and girls and to ensure equality between women and girls and boys and men. So that is what the CEDAW Convention is. The CEDAW Convention, it is...
Just to check you out, is this the convention that was born in Beijing?
So Beijing is just an international agreement. CEDAW is the enforcement mechanism for Beijing.
So this is the Beijing in 1995.
This is 1995. CEDAW, so I'm going to that. CEDAW convention was passed in 1979.
Okay.
And that CEDAW convention is the one that also continued to give talks to continuous conversations on women and girls. That is why that Beijing platform was formulated. But now the CEDAW convention establishes a committee that is supposed to monitor how state parties implement that treaty of CEDAW. So CEDAW is ratified by 189 state parties, meaning it is nearly universally ratified. Only about 6 countries have not ratified CEDAW. So in Africa, we only have Somalia and Sudan. Then, of course, the others are Holy See. The US has signed but has not ratified. So about 6 countries. So you can understand that all other countries.
It is America, Somalia, Sudan, and who else?
Palu,
Tonga,
and Niue.
And where?
Niue. It's there are 3 countries in the Pacific, and also Iran.
Now you didn't say those countries again because Alfred has never heard of them. He thinks you're talking about.
Palu.
He thinks you're saying PLU.
Imagine, is that how they pronounce it? Yeah, yeah. But anyway, so most of those 3 countries, Tonga, Niue, are all in the Pacific, and then Somalia and Sudan are our neighbors, and then the US has signed but has not ratified. Then there's the Holy See and Iran.
Iran.
Yeah. So those are the countries that have not ratified. So when you have not ratified CEDAW, it means we don't have legal jurisdiction over you. So you see the war that is happening in Sudan right now. Women and girls are suffering most from the impacts of the conflict, but our hands are tied.
Even the one in Iran, it is women. They're bombing nursery school girls. But
anyway, so we don't have locals. So in brief, that is what. So that convention establishes the committee on which I belong to. So this committee is mandated to hold governments accountable on how they promote women and girls' rights, gender equality. Then we form, like what Ambassador Adonia mentioned, we form international jurisprudence on women and girls' rights. We are also a quasi-judicial body, meaning because there's an optional protocol. So if you feel that your rights as a woman or girl has been violated, you can file a complaint with a CEDAW committee, and then we shall be able to look at it.
So a girl in Uganda can sue who can you take to the committee? The government or Alfred? Can you take the Alfred?
So it is that we'll go in detail later when we talk about international law, but under international human rights law, it is a state party that is held accountable for its failure to protect women and girls from rights violations. So in a nutshell, but because Uganda has not ratified the optional protocol to CEDAW, anyone in Uganda cannot utilize the complaint procedure.
So it means you must agree as a country
to allow girls to take you to New York court, and Uganda has refused people like Joy to sue them.
So Joy from Uganda cannot file a complaint about Uganda before the CEDAW committee. But because Uganda has ratified the CEDAW convention, it means when we're having constructive dialogues with her. So let me just give you a brief of what. So this CEDAW committee, there are 23 experts. We are all from different parts of the world. We are elected.
You're one of them.
I am one of them. And we are elected in New York. But as Ambassador Adonia has already given the procedure. You're selected by Uganda. Uganda selects you. Then you go to the African Union. That's Ambassador Rotengo. And then you go to Ambassador, the one who him and the team in New York manage the election. So when you get elected, you're best in that committee. You join the committee, and you're best in Geneva, in Switzerland. When we have sessions in Geneva, state parties, all those 189 member states, come to Geneva to report to us what they're doing for women and girls, what they're doing to achieve gender equality. Uganda submitted its report in 2022, and it's every 4-year reporting cycle. So a head of delegation comes to Geneva, country delegation, maybe 2 ministers, 2 other technical staff, you all come to Geneva. But so then we have a constructive dialogue with the state party. We ask questions, we pose questions, and civil society also presents to us before we meet the country. But to tell you why this is important, I'll bring it home to give you 2 impacts, because I was just to show people why these systems are important, like what Ambassador said. When you form international jurisprudence on women and girls' rights, how the impact. We had Benin about 3 months, last year, that came to, I give Benin because it was just a weekend that we saw change. So what happened is we realized that women and girls in Benin have challenges in accessing justice. And yet, when you have a right violation, you need a remedy, you need to go to access justice. But they didn't have, justice can be expensive. Many women and girls, because of the gender gaps, cannot afford to even go to court. So what happened with Benin? We had this dialogue with Benin on a Friday. So the Minister of Justice, we of course told him these are our priorities, recommendations that you're supposed to, that we would want to see implemented to improve the lives, day-to-day lives of women and girls. What Benin did, what the Minister of Justice did, this was a Friday, we finished at 5 p.m. So that Saturday, Sunday, Monday, first thing in the morning, we received a note verbal from the government of Benin saying the president had passed a presidential decree on access to justice for women and girls. So do you see how impactful the work is?
What's a note verbal?
So a note verbal is a communication, diplomatic. It's a letter that communicates in diplomatic channels. So that is exactly what a note verbal is. So it is a letter.
So what happened is Benin says, you tell them girls can't access justice.
Yeah.
And then the president goes and issues an executive order.
Exactly.
Ugandan lawyers are used to the term executive order.
Presidential decree.
They release an executive order, and the executive order then says women and girls can access justice.
Exactly, and legal aid services.
Legal
aid especially, yeah. So do you see do you see the impact of the work that we do, of why the CEDAW committee is important? Because in just a weekend, of course that enforcement is going to take a while, but the fact that it wasn't there before and then it happened. I'll give you a second example. Let me go to a different region, North Africa. Bahrain had always had a law that said if a rapist marries the victim, they will not be held accountable. They will not be prosecuted. So civil society, women and girls in the country, everywhere had been pushing for that to change. Then we had a constructive dialogue. It was now Bahrain.
So what therefore, let me just understand what's happening in Bahrain. A guy goes, kidnaps a chick, rapes her, and the act of rape moves it to avoid like shame or cultural shame. He's then made to marry her.
No, he marries her.
And the moment he has married her, it's not rape.
No prosecution.
No prosecution. But if the girl jumps to marry him, or they fail to marry, then he's a rapist.
As in, of course, now those are technical details, but what happens is if that option is available and he gets married to her, he escapes prosecution.
Okay.
So which is unfair.
And that was in the law?
That was in the law. So Bahrain came before us also early in the year, I think 2024, late 2024, and this is an issue because it's a conversation that had been ongoing. But now we had an opportunity to have the government, the ministers and country delegation. So we brought to their attention that, this law has been in existence and please, it is a low-hanging fruit. Help us repeal this law. Please repeal it for women and girls because what happened? After 2 weeks, the government of Bahrain repealed the law. So you see, I'm just trying to show people how important and significant the work of the CEDAW committee is. So much as we sit all the way in Geneva, we're still very updated about what goes on because we speak to civil society, we go to countries. I know a country like Rwanda one time invited me and said, you sit all the way in Geneva, come down and see our local context, see how the CEDAW applies, meet civil society, meet government officials. So that kind of impact is why the CEDAW Convention and the CEDAW Committee are very important. Yeah.
If you're just joining us, welcome to the Judicial Service Conversations. We're having a conversation with Her Excellency Dr. Brenda Kia, and we are talking about the future of international law and we're just getting a small little peek into what she does. She's Uganda's representative on the CEDAW committee, which is the Committee for the Elimination of All Forms of Discrimination Against Women. Have I got it right?
Yes, you have.
As you can see, the lawyer's lawyer is on form. I have got it right. It is the Committee for the Elimination of All of Forms of Discrimination Against Women. And I can see a friend of mine here who really needs a lot of education in removing all forms of discrimination against women, because he's very, anyway, that is those are our problems. But now let's talk about you. Let's talk about you. And what we want to talk about you is, so you are the Uganda's representative. You're also the youngest African to serve in a leadership role in that committee. So what did it take for you to get there? And what did you have to endure to get there, and what did you learn? And we want our listeners to just understand, first of all, the setup of that committee, and then you, and how you got to be there, and just tell us about how you get on this committee, so that people who are listening can have an understanding.
Yeah. Thank you very much. I think His Excellency Ambassador Dr. Adonia Ayebade spoke to this extensively, because to get on this committee is definitely part of its teamwork. It takes people believing in you, because it takes people actually believing in you. It takes sleepless nights, it takes passion and dedication for you to be able to win the election. Like what Ambassador Adonia said, how the election is so intense, because you have about 25 countries all competing to be in this committee, because you form international jurisprudence on women and girls' rights. So if you're 25 and competing for about 8 slots, it means you have to work hard. And like Ambassador Donia mentioned, last year, the last election cycle, there was, despite having 10 Africans, there was no African that was voted in. There were 10 African candidates, but none of the African candidates went through. So, which re-emphasizes the point Ambassador Donia said, that for you to be elected, it means that the embassy, the mission in New York, led by, of course, Ambassador Donia, Ambassador Tengo, who is in African Union, of course, the MOFA, the PS Bajire, His Excellency Bajire, everyone has to work really, really, really hard.
So we may need a committee for the removal of all forms of discrimination against Africans.
Exactly. So it's really an intense competition what it takes to get there is sleepless nights, teamwork, the ambassadors believing in you. And I will tell you how we would have sessions, because you have bilateral meetings. So let me give you that process, how it starts. You start with a national level, where you approach, it's advertised, Ministry of Foreign Affairs advertises it, and then you apply to join. I think Ambassador will correct me, in that cycle were about 9 candidates from Uganda who wanted to be. Then MOFA evaluates the candidates, and because the election is done by New York, Ambassador Donia and of course the AU representative Rotengo, and the ministers, they have to choose who among the 9 is the one to go. So when they select you, you go to the African Union for endorsement, and that's where Ambassador Rotengo, who is the ambassador to AU, is the one who pushes for that endorsement, while Africa receives different candidates from all parts of Africa. And then they endorse about 3 or 4 candidates. And then those 4 or 3 are the ones who go to New York for the final election. So that is when Ambassador Donia and his team have sleepless nights. They don't sleep because they have to look for bilateral agreements. They have to meet state parties. I will give you an example, and I don't know if Ambassador is still on, but he can testify to this. We met, my first election, we met 188 countries, campaigned with them. There are 189 state parties, meaning it was only one country that we did not meet. Do you know how sleepless nights that means? There's the issue of time zone, but it's not only me who is not sleeping, it's the entire team. I went, because we are doing a re-election campaign, I went to New York the whole of March. We met 129 countries in 2 weeks. So you can imagine the back-to-back. So that is really what it takes to get on that committee. But once, so it's basically, and that is why when you've gone through that level of leadership, of campaigning at the international level, it takes me back to what I said earlier. You realize from the beginning that you are not, it is not about you. Your success is never about you. You only contribute, I think, 0.1%. Everything else is done by everyone who believes in you, who pushes for you, and really wants to see you there. So that is basically what it took to get there. But I think for me, what this has exposed to me is, one, the fact that like you mentioned, you mentioned, I think an ambassador said, Hawaii, there's now a shake in international law. There's a lot of geographical underrepresentation in the United Nations, in the entire multilateral system. I just mentioned 2 years ago when it was election cycle, out of 10 African candidates, there were about 20, there are always about 23 candidates, 10 were African, none of them made through. So you imagine, if there's no African at the table, Africa becomes the menu, because you're not there to influence what is made. You're not there to influence context-specific jurisprudence that fits the context of African women and girls. So that is why it is important. So that geographical representation means our voices are excluded. So any jurisprudence that's made there means it will not effectively apply to us, and yet we are state parties to it and we must apply it. So you see that disconnect.
Yes, it will not effectively represent us.
Exactly.
A friend of mine here is saying, is that why people are redefining women?
Probably, because but I mean, that could explain, because they're different, there are different conversations to that.
Because
so
he said that he met a woman, in inverted commas, who looked like Mike Tyson.
So you see, so if you're not at that table, you're not there. If Africa is not on that table, that is why the ambassadors have to fight really hard to have geographical representation. So without, an ambassador mentioned now it's super expensive. Then remember right now the travel and visa restrictions, that's already institutionally excluding Africa, because it's expensive to fly to Geneva.
But most Africans who would be going to Geneva wouldn't want to be
to New York
committee. They would want to be on another committee, maybe in their homes.
True, but if we're saying you want to be part of forming international jurisprudence to take your context of the Africa region there, you have to fly to New York, you have to fly to Addis, you have to fly to Geneva to campaign with all the state parties. Very expensive. Accommodation in all these cities is super expensive. So you're already excluding, then getting visas to the US. I know sometimes I have to go disturb PS Bajire and Ambassador Adonia tell me, I need a visa, I need to go. And they have to call and say, Uganda is this and that. So you imagine, if you don't have that opportunity for your government to be strongly behind you to push for your candidature, you end up missing out.
I didn't know you could get a visa like that, but now that I know...
No, you know what, Ellison, what happened is because I was campaigning.
I
was campaigning in Geneva,
yes.
And then I didn't have enough time to.
No, of course, it's a diplomatic effort, and you're representing the country, so it's different from, for example, Alfred here. And I want to hand over to Alfred here. If you're just joining us, we are having a conversation about the future of international law.
But just before you finish, because I was talking about the underrepresentation, and it also ties back to what Ambassador Adonia said. Sorry, I keep referring to him because he gave, I think, a whole blanket of what is international law. When international law was made then, even these conventions, conventions were way past, but they were made during colonial rule. Africa was still under colonial rule. Of course, CEDAW no, because that was 1979. But when you look at most of these international treaties, they were made 1940 something, 1950, 1960. We were still under colonial. We didn't have a voice, and that is why Ambassador is saying now that it's starting to shake, they were making these rules to apply to them. To apply to other people and not them. Now that our eyes are open, it's now shaking.
Okay. If you're just joining us, welcome to the Judicial Service Conversations. Our eyes are opening. International law is now shaking. I remember Beijing in 1995, I think it was, because I think it came up in one of our exams at the time. But that time, though, Alfred was not yet born. So now, while you are the youngest representative in Africa to ever have sat on the committee, and you didn't really take us to that personal journey, but maybe we'll come back to it. But I want to hand over to Alfred. The reason why I want to hand over to Alfred before Joy is because, first of all, gender representation. We need to have male voices, and we need to remove all forms of discrimination against men. But secondly, Alfred is currently the deputy, and I know many of our listeners are bored of me saying this, he's the Deputy Secretary General of the East African Law Society, representing young lawyers, all of them. He has been elected, I think last year, end of last year he was elected. So he's also an elected man by Uganda to represent all of East Africa. Uganda was given the chance to pick, and they elected Alfred. He also has a group called the Dear Young Lawyer Series, and he writes to young lawyers. He has they have a group of 2. So in order to share power, Alfred became I don't even remember what Alfred is. Alfred became the chief executive, and Joy became the founder. Oh, it's the other way around. But so, dear young lawyer, there is a young lawyer here who is playing at the same level as you, but now different. For you, while you stop in Arusha, Ash is in Geneva and New York. Ash is in Geneva and New York, and as she's in Geneva and New York, for you are here in East Africa. So now you ask questions about international law, but understand that now we have gone global. We've gone global. There is government things here. There is so please.
Yeah, thank you, the lawyer's lawyer. Indeed, today I'm going to ask questions about international law. Yeah, for those on call today, international law is being tested. The rules that guide our countries act on war, trade, and sovereignty, which don't seem certain as they usually did, are really being tested. And we have an amazing guest who is answering the question of whether international law is still law or it's now about power. When you're talking about CEDA, I saw someone in the comment section talking of whether there is a committee on elimination of discrimination against men, so that he can also maybe join to be the youngest person on that committee. You will answer that. But since we are dealing with the national law, as you said, my question regarding international law is whether the bit of where we are living through a moment where international law seems both everywhere and nowhere. In simpler terms, someone will say international law is busy. You know, when you like how you can be busy but not working. So is international law being busy but not working? I know even in ambassador submission is mentioned hinted on it that sometimes powerful states invoke it when it's convenient and sometimes ignore it when it's not. But from where you sit on the committee, you sit on your representations you make, my question is whether really international law is still a system of rules, or has it become a language of power just being applied when it's convenient to do so? Thank you.
Thank you very much, and congratulations on your role. I really love engaging with young people because you are really the future, and it's very interesting to see that you took up such a leadership position. So congratulations. Before I answer your question, I think it's important because I know, like you've just said, and Ellison said, and also Ambassador Donia has been talking about international law. But I guess we need to understand when we say international law, what is international law? Can any of us describe what international law is? Can any of us describe what international law is?
The law of America, which it imposes on Venezuela.
I plead the fifth on that one. Yeah, but that is how many people understand international law,
including some presidents in America.
It is, yeah. I mean, when you look at what's going on, you may say that it's for maybe the powerful countries,
yes,
and it's them who utilize it.
Or the law by which the European Union refuses African goods into their countries.
Yeah. So what you're talking about is interesting because yes, international law does govern different areas of between states, between organizations. So even international trade is part of international law. So you're right. But I guess for our listeners, just briefly allow me to give you. So international law is just basically legal rules, norms, standards that regulate or manage how states relate with each other, how states or countries, or how organizations relate with each other.
Like
so
the stuff that makes these guys here, sorry to interrupt you,
No,
the
please
stuff
go
that
ahead.
makes diplomats have diplomatic immunity.
Exactly. So that is also part. So now international law, after saying how it manages, it has different areas. When you look at maybe cyber crime, or there's a specific convention that talks about cyber crime, convention on cyber crime. If we are talking about climate change, there's a specific international law treaty that governs how states and international organizations should deal with climate change, and that's the Paris Convention.
Yes.
Then with women and girls, it is the CEDAW Convention. With maybe children, it is the Convention on the Rights of a Child. If
human
so
rights.
Guy, you know these things so well.
The human
if it's
rights.
international trade, it is. So it governs.
The GATT and WTO.
Yeah. So exactly. So you know all these things, Ellison man. So that is exactly what international law is. But what is of interest to most of us is the one that manages state-to-state relations, which is currently on fire right now. Yeah. But for you, let's also understand, how does this international law come about? They can be formed in either maybe two different ways. One is through treaties and conventions, and those treaties, the examples you've given, they just come about by consensus. They're just international agreements where country A, country B, country C, country 100 come down and say, let's agree that if we are going to trade in oil, we are going to use petrodollar. Let's agree that we are going to use the SWIFT system. Let's agree with it will be, we shall finance climate change. So you just agree, and it is by consensus. So that is how all these international agreements, which are called treaties and conventions, come about. The United Nations is also what usually is the one that drafts many of these treaties. So that is why there's the UN Convention on Rights Against Torture, UN Convention on Persons with Disabilities. You get. So that is basically what it is. Then there is also a second way international law is formed, which is customary international law. So I'm just trying to give a small understanding of, so that some people who don't know, then there's also that customary international law, which is just practice, where you say, countries, it's not written, but countries have said, let's agree that torture is bad. Let's agree that slavery is bad. Let's agree that crimes against humanity, conflict-related sexual violence is bad. It may not be written, but you've all agreed because it becomes practice, it's uniformly applied. So that is basically what international law is. Yeah? And of course, as I said, it does govern different fields. But the one we're interested in relation to your question is the aspect of the international law that governs relations between countries. I mean, your question is two-part. Some people may say it's no longer about rules, it's just about power. But you must understand there's also an impact. So I'll answer your question in two ways. Your question is a critique of international law. But let me first talk about the positive aspects of international law. Look at the ICC, the International Criminal Court. Exactly. When it started in 1998, what happened? It was issuing arrest warrants mostly against Africa.
Yes.
Africa. But to be fair, it was not them coming. It was Africa that was recommending, referring these cases to the ICC.
The Joseph Kony's.
So we referred these cases. But why I'm saying that was positive is because the victims of the LRA, let's say for Dominique Ongwen, what happened? They got justice. Okay, justice is relative, but the fact that
there was a trial.
So many of them are happy. Some of them are happy because, also justice is subjective. Some people would want just compensation money, but that trial made sure that now they can get reparations, they can get compensation. But you see, that is a positive in terms of saying, at least we saw justice being done. Look at the ICTR. When I was younger, when I finished...
The ICTR is International criminal
yeah,
tribunal for Rwanda.
Elisa, you know these things very well. You're the senior counsel.
The lawyer's lawyer.
Lawyer's lawyer. So yeah, so ICTR prosecuted the perpetrators that committed the genocide against
The Tutsis.
Tutsi in Rwanda. Many of them were convicted. I worked as a legal researcher on one of the cases called Nizeyimana.
Nzeyimana, this is the guy who was the newspaper guy
I think
or
so.
the radio guy.
I forgot, but yeah, one of those. So clever, Elisa. But anyway, so
I'm just guessing.
Guessing right.
yeah, but I'm just trying to show you the positive. So most of those convictions at the ICTR, what happened? Perpetrators who committed the genocide against the Tutsi got the justice that these guys were convicted. And of course, Gacaca continued. But that's international law. ICC statute, Rome statute, that's still international. That is a good sign. The cases I've given you about Bahrain, about Benin, that's also international law being positive, transforming our day-to-day lives. But of course, the critique you're talking about is the aspects of, also, let me say another good thing about the ICC, international law, which is the Rome statute. Right now, we've all heard of stories where countries are announcing if ICC has issued arrest warrants against certain heads of state, you can do your research on who has been issued arrest warrants against. You hear state parties saying, governments or heads of state saying, if you come to our country, we're going to arrest you.
That's Israel.
I don't know. I've not done the research. But yeah, but anyway, whoever can do research, because I'm not very.
You have to keep warning us because we appreciate that you need votes. So when we are misbehaving.
No, I'm just saying. I'm just giving you an example of you'll hear heads of state saying, if you come into this country, we are going to arrest you because there's an ICC warrant that has been issued against you. You've also heard of stories where let's say an arrest warrant has been issued against me and I have a private jet, I'm not going to fly in your airspace. Because why? I am scared that I could still be arrested. So just see how important international law still remains relevant. Like what Ambassador Donia said, it is here to stay. It remains relevant. But of course, the critique, where you say as a language of power, you must look at the current problems that are facing international law, the criticism, which is of course like Ambassador Donia said. Sorry, I keep referring to Ambassador Donia because he gave us a whole blanket of the aspects of international law.
And he's a very experienced diplomat.
Exactly. So one, we talk about the double standards of international law in multilateral and also in multilateral debates concerning international law, right? International law is being applied inconsistently, depending mostly on how much a country's GDP is.
Yes.
If you're wealthy, I can disregard it. When Africans are being prosecuted at the ICC, yes, the ICC is being applauded. It's doing its job, it's doing well. But then when warrants are being issued against others, what is happening? Sanctions.
On the prosecutors
or on the right now it's on the judges. So that gives people the criticism of saying is really international, really relevant. It's so double standard because why are you applauding when it's someone else, and then when it's now applying its international mandate, you're sanctioning.
Is that criticism legitimate?
So that is maybe what it's subjective. The other people, it's like an 8. Maybe the other countries are saying, the ones who are sanctioning are saying it's not legitimate. These others are saying, but it's not. But again, that's what now, our job is now to leave the debate for our viewers to determine whether it is.
Because I want to push back a little bit. And again, you'll just have to keep signaling me when I'm not being diplomatic. Because you talk of, for example, what you call customary international law. Maybe. You talk of what we call customary international law. And if I'm thinking of some of the examples of customary international law, that is international law. So we have treaty international law. For example, the East African Community Treaty. It is a treaty and it is enforced. It even has a court in Arusha that enforces it. We have the African Union Treaty that establishes the African Union. We have the UN Charter that establishes the UN. We have the laws of the sea. We have the laws of all these things, and we have climate. We have all these things, the Paris Climate Accords. All this is international law. The different things that countries negotiate, people like Ambassador Donia go and negotiate. They finish negotiating in Sharm el Sheikh or in Beijing or in Kampala, because even ICC, part of the declarations of ICC, people may not know, were made actually in Kampala. They are Kampala declarations, I think, on aggression.
Yeah.
It's a war crime to commit aggression against another country. That was agreed by the countries in a Kampala declaration, and it forms part of the of the ICC and the Rome Statute. But you look at customary international law, and there are things like, for example, sovereign immunity. There may not be a treaty about sovereign immunity, but it's generally agreed that if a president of Kenya is visiting Uganda, he comes with immunity. But why people are questioning things like international law is because sometimes a president can be in his bed in his country, and another country comes and arrests him and then charges him with having guns. Can you imagine charging a president with being armed? What is he supposed to I mean, there's a president currently in a country, but we're being diplomatic. But in a place where Ambassador Donia lives, there is no, but we shouldn't tell people where this is. Although he lives in New York, but in a court in New York, there is a president being prosecuted for illegal possession of firearms. He was picked up in his country. I don't know which law was governing the possession, but the point is, those criticisms. You look at anyway, there are many different things. But when I think of customary international law, the one thing that quickly comes to mind, it's an international custom that countries respect leaders. But now you have people saying that we had a smart targeting, we got intelligence, and we blew up the leader. The question is, that criticism that Alfred makes, isn't it really very, very legitimate? That at the moment, international law is on its deathbed. The customs that have governed the world have died. Okay, but you, when you say it, don't hurt your campaign chances as Uganda.
So I want to let me take you back to that debate that you mentioned in terms of heads of state and immunity. So I remember when I was at the ICC, that's the International Court, Criminal Court, there was a case, I totally forget where, anyway, it was about immunity, because there was a warrant, I think, against Bashir, and he went to a certain country, Jordan, so they were filing a case against Jordan or one of those countries that said that their failure to arrest. But the challenge, though, is, and that is what we need, that's why I can't confidently give you an answer, because there could be an impasse. There's one side that says heads of state have diplomatic immunity.
That's customary international law.
Customary international law. Even some treaties have also codified that. But then there's also another aspect of international law that says no one is immune from crimes like jus cogens, crimes against humanity. So just see the impasse that is created.
But for the ICC statute, we all agreed. People signed and said, I am the head of state. In case I am indicted, I lose my immunity. So that one is agreed.
Impasse. That's exactly what I'm talking about. There's an impasse. Some are saying, but customary international law says I have immunity as a head of state. Others are saying, but how come ICC or another jurisdiction?
But Bashir is different from the Venezuela guy. First, look at the Venezuela guy.
We're talking about heads of state.
Yes.
I think that's what it is. We're talking about heads of state, right?
Yes,
Whether it is country A, country B, country C, we're talking about heads of state. But why I'm bringing that, because these are legitimate questions, an impasse of international law. That is where the criticism is, and maybe that's why some countries are able to get that loophole and escape maybe accountability or something. So it is about that impasse. And that was a practical example for heads of state. When you go into the nitty-gritties of specific heads of state, then we may spend a whole day here.
I agree.
But also, just to answer, then there's that aspect of polarization of international law. Do you know which stems from interpreting international law? Is it on? Which stems from interpreting international law? For example, let me say that what international law of armed conflict. It's universal that you're not supposed to attack hospitals. You're not supposed to attack maybe civilians.
Bridges.
You're not supposed to attack bridges, water, electricity. But then I'm country B, and I say, okay,
You're not okay.
uh-huh.
I was going to say, you're not supposed to remove someone from the civilization. You're not supposed to eliminate a civilization.
I mean, those examples that are prohibited by the Geneva Conventions.
Yes.
Yeah. So I'm giving you the polarization of international law, which warrants why people critique. So you're reading the convention. Let's say Article 1 of Geneva, I'm just forging Article 1 of Geneva Convention, says exactly what you have said. Don't attack water, electricity sources, etc. But me as country A, I'm like, I am going to attack. Like, I totally disregard that Article 1 of Geneva Convention. Then, as, let's say, you're international law practitioners, you're now evaluating whether there is a violation or not. Me, who is basing on what the text says, I will say, this is clearly a violation. But then another international law practitioner will say, no, this is not a violation. So the polarization of international, so it leaves you
That's
who is
called
reading
polarization.
the text. Yeah, it
I
leaves
like
you
that.
who is reading the text very confused. Like, to your sanity, you're wondering, but this is what, you even go to maybe someone and say, isn't this what it says? Article 1 says do not bomb bridges, do not bomb water sources or electricity. And yet the other person is telling you, well, that's not true. That's not what they did. Or it was they justify the action. So you see how that leaves you very confused. So everyone now decides to interpret it the way it is. So when you talk about, is it a source of power? And usually you get, if you evaluate and see who are those trying to, based on polarization of international law, to be able to maybe get away with many things that they are doing. But importantly to this conversation is, what is the role of money and international trade systems in international law? I think
The
that
role of
is
money.
of money and international trade systems. Because if you look at right now, it is the core.
Poverty is an international offense.
Yes, maybe. Because if you look at the countries that are maybe disregarding international law, the GDP is really huge. Yeah. So which brings you the question, is it because is it because you have a lot of money, your wealth, or you're really wealthy, that you're able to disregard international law? Or is it because I am broke, I can't disregard international law, I have to abide by the rules? So, but
Sorry to interrupt you. I have a friend. This sovereignty law, I'm not going to ask you about it, but this sovereignty law, a person, very rich person, who asked for an opinion about the different provisions and realized that he would be affected. So he asked, can he, because there are so many fines in the law,
yeah.
can he prepay? Can he deposit? So that's what you mean by rich people sometimes don't think the law applies to them.
Yeah, so I guess it is everywhere. So it's not even only international law. So I guess it is everywhere. So you see, the problems that face international law are not unique
To domestic law.
to domestic law, because it is clear, and that is where they say, is this where they say international can be law can be a double-edged sword. For
Yes.
me, I may utilize it because I have money and be able to get away with so much. So the same problems. So we've brought it home. The same problems that face national law, rich people can get away, and wealth is. So do we still say domestic law is not important? We still apply it. We continue to use it, but the fact that it has problems or issues doesn't mean we should disregard all of it. It just means it gives us an opportunity to rethink the system, to rethink how can we make it better suited for our lives right now, the current situation. Like, how can we make it fit our context? So, but then I wanted to take us back to that aspect of how, like, wealthy nations does international law, I think that's a question people, for homework, does international law favor wealthy countries? Right now, we are seeing the petrodollar. There are conversations around the petrodollar. Look at the SWIFT system. It is governed because it's based on USD. So do you know how much power that gives the American system?
With the
It
Cloud
gives-
Act.
Exactly. It gives you so much power that now we need to understand, is it how can we, so that's where the rethinking comes in of should this continue? Should we be able to think and say now that we have a voice? Because most of this international law is formed during colonialism. The UN Charter was established, that established the P5, Permanent 5 on the veto, which I know Uganda's chair, as NAM, headed by Ambassador Donia, is really trying to fight. So for me, again, Alfred, as a young lawyer, all these criticisms are very important because we need to, this gives us an opportunity to think, how can we make international law work for all of us equally, irrespective of our economic wealth, irrespective of whether I am rich or poor? How can international law work for us? Right now, I think, as I say, does international law apply equally? When you look at the UN, United Nations, when it's time to vote, the P5 can veto. What does that mean? There are conflicts that could have been stopped if there was no veto. But because of veto, we can't. And for those in the audience, what we talk about veto is the aspect that at the United Nations, there's the UN Security Council. The UN Security Council has 15 members, but there are 5 who are permanent. The 5 permanent members are United Kingdom, France, Russia, China, and United States of America. So these have the power to block a resolution. So you may have a resolution that says we are stopping war in country B, but one country vetoes it and the war will continue.
Or we're attacking, like the Iraq resolution, and France. or we're attacking and America vetoed the attack on... I don't think I've ever done that, but...
Hypothetically. Yeah, but anyway, so things like that, we need to rethink. Should we continue to allow the veto to work? And that is why, as young lawyers, this is the conversation you need to have. Should we continue to have the P5 have the veto power? Should we reform that multilateral system so that international law applies equally to all of us, that each of us has one vote, not one person being able to veto? But I think an important conversation that we miss out when we are critiquing international law, we hear about selective application, we hear about the veto, but it's the aspect of sanctions. You know, as we mentioned, the SWIFT system and what all are heavily controlled by maybe one country.
Even AI right now.
Yeah. Please go ahead.
No, even AI is controlled in one place.
Yeah.
And the guys who control AI have passed the Cloud Act, so they can just take your stuff.
Exactly.
They can lock you out of ChatGPT.
Exactly. So that is also
and I know a guy who'd stop writing immediately.
God. Yeah, but so you see, those are conversations that young lawyers right now, you need to rethink, that how can we ensure that if we have another crisis or we are thrown into chaos, that international law remains solid, because international law gives us the basic standard that we must follow. So young lawyers, I think my plea to them is to now use this as an opportunity to rethink all the criticisms that international law is facing right now and be able to ensure that it applies equally to all of us.
Well, thank you. For just joining us and you missed the other part of the conversation. This question is recorded on YouTube, on our channel of Service Conversations, and even on TikTok. So if you are doing international law as a law student, you can always go back to this amazing lecture on international law. But there are very many comments in the comment section, and I would like maybe you to answer some of the questions or to comment on some. There is Emily Migade is asking, with the ongoing conflicts in Ukraine, Gaza, Sudan, is the national humanitarian law dying, or is it simply being reviewed as actively applied? I think I should join it with this question of, Africa has always been on the receiving end of the national law rather than the shape of it. Do you see it changing in any meaningful way, or we are still going to operate within the framework which are designed elsewhere? Thank you.
Yeah, I think this reminds us what I talked about earlier. You've said Africa is always on the receiving end, but the core as to why that happens is what I mentioned, the geographical underrepresentation. Because as I said, that's a common saying, if you're not at the table, you are on the menu.
Yes.
Yeah.
Mm.
So if you're not part of that discussion,
If
formulating
you're not eating, you're
international-
being eaten.
Exactement. Right? So if you're not part of that conversation of influencing how international law is passed, how the ICC is developed, things like that, you're definitely going to be. So that is why geographical representation is important. That is why Uganda or Africa fights so hard to have representatives in these different multilateral systems, because it is important. So for me, that is the biggest, one of the biggest challenges for us, why Africa is, as we say, as Elton has said, if you're not on the table, you're eaten. So I think what young lawyers also need to do now is to now start exploring ways for them to be part of these conversations. Yeah? Because when you're part of these conversations, that's what it is. And which takes me back also to the ICC, because I know what you're saying. When ICC had begun, it was mostly African countries being, Africans who are being. But right now, the trajectory has changed. We are seeing more and more ICC issuing warrants against other people outside Africa. So I don't know if that conversation still counts. But of course, importantly to that. And also, if women are not at the table, or are not forming part of international jurisprudence, or are not forming part of conversation like AI right now, because now I'm passionate about technology and artificial intelligence, women are missing from STEM. Yeah?
What's STEM? Tell us STEM.
STEM is science, technology, engineering, and math. You need these skills to be. Women are not men that gender coding and doing all this. You're going to, if it's mostly men, what is going to happen? Everything that is being developed is going to be based on men's perspective. And if it's coming to how do you integrate women's specific needs into AI? But women are missing from the table, or women and girls are missing. So what does this mean? One, AI or technology is going to push discrimination against women. Women are going to suffer because of the violence, because yes, you may understand the plight of women, but you will not fully understand it 100%, like if a woman is part of the conversation. And then two, we're also talking about the digital divide already. We're talking about AI, we're talking about all this, but if you look at the gender digital divide in Africa, it is huge. I can get you an example of, anyway, there are statistics where they say in Africa, I think ITU last year released data that
What's
showed.
ITU?
ITU is the International Telecommunication
Whatever.
Union, whatever. It's based in Geneva. But what they released is, I can get the statistic, but anyway, it was about 34% of women in Africa access the internet. In Europe, do you know how many? 94%. See that disparity.
And men?
Let me get you the data properly. So
Okay, but so 34% of African women
Yeah.
access the internet,
yeah, let me
and
get it
90 what
right.
percent in Europe?
I'm trying to get it here. 1 second. Go right here. So, actually, I even increased it. 31% of African women compared to 43% of African men use the internet. In the EU, 90% of women and 92% of men use the internet.
So less than half of Africans use the internet.
Exactly. So how are we talking about inclusivity? See how AI is also going to leave us behind, because we are not part of that conversation of. And then when they form different things, we'll say, oh, but it's not meeting our context. And yet we are not there.
Wow.
And then look, for me, something that I'm very passionate about, that I always talk about, but also have seen firsthand from my experience on the committee, because I have a 360 view of 189 countries. One of the biggest challenges I've seen is the aspect of electricity. Can you talk education without electricity?
No.
Can you talk health without electricity?
No.
We are talking about digital technology, AI. Can you talk when we don't have electricity?
There is more electricity to power the swimming pools of California than there is in the continent of Africa.
What? That is even terrible. That's terrible.
There is more energy used by 4 million people in Alabama than by 1.2 billion people in Africa.
Wow. Listeners, do you hear that information? So young lawyers, these are the things you need to be, the practical, because you can talk international, but how are you practically enforcing it? You don't have electricity, how are you talking AI convention? But thank you so much. That even makes me very sad, because I was just going to quote data of saying of Africa, like access
Give us
is
data.
about 40%.
Access to what?
Huh? Africa has the lowest rate of access to electricity with just over 40%. So half, more than, basically.
That is more than 600 million people
Exactly.
on the continent.
640 million.
640 million people on the continent. You get only these statistics on the Judicial Service Conversations.
Yeah, so young lawyers, I think this is the challenge, because these things are the ones that, so that gender representation, and I mean, when you're missing, there's no gender representation, there are no women and girls missing. I mean, there are women and girls missing. We don't even have representation in STEM. We don't have electricity to even be part of these serious conversations.
And STEM is what again?
Science, technology, engineering, and math skills, because the divide is huge. More men graduate from STEM fields than women.
I think we're only overrepresented in
In what?
in witchcraft.
Yeah. And then, so these are conversations. And of course, something that's also pertinent to international law, we're talking about wealthy countries. What if we could be wealthy if we were able to, you know, that debt financing, how we lose a lot of money from things like illicit finance. 24 low and middle income countries are paying interest payments estimated at USD 415 billion, which is even 2.4 times what was paid a decade earlier. So you imagine all that money that we are losing, that we could be using to create our wealth that could maybe allow us implement international law better. So I think as a young lawyer, these are things you must be able to, your colleagues should be able to really critique and understand. Then you can be able to engage fully on international law and ensure it's fully implemented. Because if you don't have money, how are you implementing many of these things? Climate change itself, we are saying climate financing, we can't afford. If we're losing all this money to debt financing or illicit financial flows, what is happening? It means we can't finance our own climate change adaptation. Yeah. So anyway, just to say why Africa, in summary to your question, Africa is missing out of this conversation. So it's important for us to be there. And so that we are not saying, oh, we are just on the receiving end of international law. Geographical representation is important. That's why I, being on this position, and our African colleagues being on the committee or in different multilateral systems is important. And that is why, like Ellison, why it was important for me to be in New York when Mofa, P.S. Bajere said it is important for Uganda to go and campaign. We need to try and get Brenda there, because I was campaigning in Geneva, so it's not like I was on a chill, I was doing nothing. No, I was campaigning, I didn't have enough time, and Uganda had to fight. So it is important that women and girls are at the table. It's important that Africa is represented, Uganda is represented at the table. If not, like Ellison says, you'll be eaten, and you'll continue to be on the receiving end.
Thank you. I think the young lawyers who don't have money and they want to address such challenges, they talk to the lawyer's lawyer and the financiers, so we shall sort that. But I saw comments in the comment section. I will ask some of them, you answer them, George will come in to add on them, but I just want to answer this from Kakunda Estelle. He's saying, Dr. Kia, as chair of the African group in SEDA, how do you balance universal human rights standards with African cultural sovereignty when countries like Uganda or Kenya face pressure over issues such as bride price or female genital mutilation? Maybe I could add also one from Jesse, is asking, in an era where powerful states increasingly bypass the UN Security Council, how can SEDA and other human rights treaties retain relevance when prohibitions like the use of force are openly challenged? I think we can answer that in the meantime. Those from Seguia, Enoch, and others, answer, I think Joy will come in with those. Thank you.
Thank you very much. Our work on the CEDAW is guided by international women's rights principles and values and standards. I know for a fact that Uganda has, and many countries have outlawed female genital mutilation. So one of the biggest issues comes down to enforcement.
Yes.
And that is where enforcement becomes very critical. This brings in the conversation of CEDAW. So as we do our work, we are guided by basically international. So I'm not going to be influenced by saying, oh my God, FGM. You look at the data, you look at the statistics. What's the well-being for women and girls? What are the dangers of FGM? So that helps to guide you. And when we come with those decisions, we've talked to women and girls. They've shared their lived experiences. We have talked to government officials. We have talked to civil society. So we've talked to many people. We also go to the field to speak to individuals. We don't only sit in Geneva. And so that really shapes what the CEDAW comes out in terms of harmful. We call it harmful traditional practices, child marriage, female genital mutilation, things like widow inheritance, all those perspectives that continue to exist. We weigh the impact, the disadvantages over what the benefit of eliminating them, the economic impact on the country for continuing to drive these things. But what I wanted to say also is, when you're working on the committee, many things come to your attention. You hear firsthand from women and girls. You hear what they want. You hear the things that they're pushing for. And when we make those jurisprudence, I will give you an example. Recently we had DRC come in at the height of the war. The government came in to brief us on what was going on, the context of conflict-related sexual violence. Women and girls spoke to us and shared with us what they're experiencing in terms of conflict-related sexual violence and its impact. So what happens is when the CEDAW comes up with this international jurisprudence, that is the concluding recommendations or general recommendations. Right now we're working on a general recommendation on stereotypes. What happens is how now people on ground, like civil society, individuals, young lawyers, community leaders, how they utilize this jurisprudence that the CEDAW makes. So that means once we've established this, the enforcement is joint efforts. It comes down to you. If you're civil, we have FIDA in Uganda. They can decide to say, okay, CEDAW has said, eliminate governments, establish maybe 10 more police desks. It's about a civil society or individuals or women leaders coming up to say, let's implement this recommendation. So this is all joint efforts. Our jobs is mainly to highlight what needs to be done, to establish the jurisprudence, and work with you on ground on the enforcement.
Thank you very much. Thank you very much for that, Ms. Brenda. Once again, it's a privilege to have you with us this evening at the Judicial Service Conversations as we discuss the future of international law. And to everybody that has joined us this evening, we appreciate you. Thank you for taking the time to learn, relearn, and be part of the conversation. So I will just go straight to the audience. We have a few minutes to the top of the hour, and I will just take us straight to the audience and see what they're saying. There's a comment from Council Aloyo. He's a faithful listener of Judicial Service Conversations, and he's saying international law has always been written by the victors, but today the victors are no longer a single bloc. The rise of BRICS and African Agency is forcing a genuine pluralization of the rules, not just rhetoric. And then there was also a comment from King Anthony. He's saying, greetings to everyone here. I thank those who have planned to give us this intention of the future of international law. Thank you, His Excellency Ambassador Adonia Ayebade of UN for joining the conversation. Okay, so straight into the questions. Seguia, I see you have like so many questions, but we'll see if time allows. So I'll just pick one out, and if time allows, we'll circle back to the rest. So the question that I'm picking out of the many that is sent in, how should global human rights frameworks adapt to the realities of protracted conflicts across Africa, such as those in Sudan, the DRC, and the Sahel, where state institutions are weakened, sovereignty is contested, and external actors often fuel instability in an era of shifting geopolitical alliances with BRICS and growing skepticism towards selective enforcement of international norms by powerful states? Can these frameworks still serve as neutral tools for peace and stability, or do they risk becoming instruments of influence that undermine national priorities like security and self-determination? That is his question. If you can answer that, then I'll come back with another. Over to you.
Thank you very much for the questions. And I think for us on the treaty bodies, and I will speak on the treaty bodies because I'm sure it applies to all the other treaty bodies, we evolve with emerging issues that are affecting international human rights. Specifically, let's talk about the CEDAW. We know we have general recommendations that were created in 2009, 2000, maybe 10, 19, something. And we realize that does not apply anymore. So what are we doing? We are starting to add addendums to speak to the current situation. Right now we are working on that. We had a 2013 general recommendation, international jurisprudence, that spoke to women in conflict prevention, conflict and post-conflict. We realized 2013 is so many centuries ago. We need to evolve. Currently, we are seeing so many conflicts coming up, and with nuanced crimes or violations that are happening. So what have we done? We have now developed an addendum that speaks to women in conflict. We actually receive comments from the public. So if you feel that there's something you need to say, that you need your voice to be heard, and you need something that you think is so pressing needs to be reflected, you can reach out to the treaty bodies or the CEDAW committee. So this addendum to...
How do you reach out?
You go to the CEDAW website, there's a secretariat email, and you can feel free to reach out and share any information that you have in that regard. So that is one way we are adapting to the current situation and the emerging issues that are happening. And then the CEDAW treaty bodies, many of them, I know my colleague Laura Nyunkindi on the working group of discrimination, they already did a report or a document on digital technologies. But now CEDAW, we've never had something on technology, on artificial intelligence, and we are realizing we must, because we are seeing the data where there's lots of violations happening online, and yet rules continue to be missing. So now we are starting to work on a general recommendation on digital technologies. You spoke to DRC. One of the questions, I think I just mentioned earlier, one way we do, the reporting cycle for DRC was not due at all for I think the next 7 years or so. But what we did when this war broke out in February, I think we're all familiar with that war, what did the committee do? We reached out to the government of DRC and asked them to come to Geneva to explain to us the situation on ground. Their session wasn't due, but you see how we made an exception for DRC to come. So that is how these treaty bodies remain very relevant, and that is how we work to address emerging issues that are facing the current generation.
Thank you, Your Excellency. So, Seguya, I hope that answers you. I'll just pick one more question after reading these comments from still the audience. There's a young lawyer, she's called Penina Noreen, and she's saying that she feels like we as Africa have a long way to go. All these international law issues come from poverty. We don't have a say on anything. We only seem to have a say, like power comes from Africa. We have a say that power comes from Africa becoming one of the world's giants. Otherwise, we shall stay on the receiving end. I think she's trying to say Africa has to work hard to rise out of poverty so we can have a say in some of these things. And then there was also a comment from Luis Inquisito. He says the 1944 Articles of Agreement is the governing document of the IMF. In 2021, the IMF printed 650 billion USD worth of special drawing rights, and only 30 billion of that free money was given to Africans. As we speak, there's been a push to reform the quota system of the IMF. That was just a comment. And then a question comes in from Jessie. She says, in an era where powerful states increasingly bypass the UN Security Council, how can CEDAW and other human rights treaties retain relevance when core prohibitions like the use of force are openly challenged? Over to you.
Thank you very much. I think the first question or comment is in relation to what we've been talking about, that Africa needs to continue to be on the table because we have been missing from the table. That is why our governments, like for me personally, the government of Uganda, not for me, but you heard what Ambassador Donia talked about, or the examples he gave of how many people he has been pushing, him and his team have been pushing to have into the multilateral system, because Uganda understands that you must be on the table. But the challenge though is you may have maybe 5 Africans on the table, but decisions under international law or in these multilateral systems are made by consensus. When you make decisions by consensus, it means you need a number of people to have your resolution or to have your idea pass. So if you're only 3 Africans, unless you're going to lobby with all the other, like now we have 23. Let me give an example of 23 on the committee. If you're saying you're pushing for something for Africa, if you're 4 Africans on the committee, what does that mean? And usually you need about 16 votes, 16 people, consensus is 16. So you imagine you're only 4 Africans. How many people are you? You have to lobby very, very hard to get to 16. So it is important that we continue to, that's why the government is very dedicated to having many Ugandans on the table, but also many Africans. So I think this is a challenge to you young lawyers or young individuals, not only lawyers, young people, that this chaos right now happening in international law is an opportunity for you to rethink your participation in these conversations. It is an opportunity for you to say, I have to be part of this conversation. My voice needs to be heard. I need to work hard and have the right credentials so that I am part of this discussion, so that Africa is no longer left behind. Like Ellison said, if you're not on the table, you will be eaten. Then the second question is that's the challenge of a multilateral system. Security Council, as we said, vetoes, but that does not stop us from speaking out. Remember, we are guided by international law principles, we're guided by international values, so you must continue to speak out. International law right now it may be facing chaos, but remember we set international jurisprudence. After 5 years, that chaos may disappear, and then it becomes what you passed 5 years before becomes relevant. So that is where you have to keep speaking up and speaking up and speaking up, irrespective of the noise and the chaos that is happening, because one day it will make sense.
So I'll just take one more and then I'll hand over to Ellison. So there's another one from Seguia, and he's saying, Dr. Brenda, in today's world where African countries and BRICS nations are proudly defending their own cultures and traditions, can CEDAW's strong rules like completely ending bride price and female genital mutilation really override the country's right to choose its own ways? Or does the fact that powerful Western countries keep breaking international law themselves when it suits them prove that universal human rights is just fancy language for power and control, not real law that applies equally to everyone? Over to you.
Thank you very much. First, let me tell you, you did mention universal human rights is just a fancy word. Actually, the reason you're here right now, accessing your phone and speaking, is human rights. Remember, some places you don't have a voice to speak to, even give criticism. So but I do understand where you're coming from, but I'm just trying to show you the impact of international human rights is the fact that you're able to speak. You're speaking, you're giving the critique, and you're here. You're even using the internet that international law is saying needs to be safe. So I hope that changes your mind about saying universal human rights is a fancy language. You are a living example that it is not fancy, that it works and it creates impact. But again, you speak about FGM and bride price. You know, as I mentioned earlier, Article 5 of the convention is very clear in terms of harmful traditional practices. Harmful traditional practices are context specific, country by country. But what is important is, for us, the CEDAW, when we say harmful practices, and if it's a country like Uganda, we shall identify, because it's context by context. Because as we are doing constructive dialogue with state parties, we go context by context, we go per country. We can't use one thing to apply to all African countries, because we may be the same, but we are also different. So, as I said, many countries have already outlawed FGM. Those that haven't, when they appear before the committee, we ensure it is one of the asks that we create. So far, we've not had a country that has we've not had a country that has not outlawed FGM. But be sure, just like the example I gave you for Benin and Bahrain and some of the positive changes that we've done, once a country that hasn't outlawed any harmful practice appears, we shall push for it, and we shall always, thankfully, state parties vote us in there to advise them, and they all usually listen to that. So it's a constructive dialogue. So it's something that we shall always push for. But most countries have outlawed FGM. The challenge I think we need to ask our governments is about enforcement. And enforcement starts with you. It does not start with, yes, government has the overall, but it's also you speaking up. There are different options. You can do a public interest litigation suit and go say, oh, CEDAW said this, national law says this, you're not implementing. So you take the government, you do a public interest case for the women and girls.
If you're just joining us, we have 10 minutes to go. You're welcome. You're in time for the last 10 minutes of this conversation. And I think we've had a lot. And I think there's that comment which I saw from I think Louis about the special drawing rights and 650 billion. 2021 was COVID.
Yeah.
So every country was allowed during COVID to go and draw because they had problems. And out of 650 billion that was drawn, according to him, 30 billion of that free money came to Africa. So out of 650, so the people who suffered the most, the people who really needed money, I think the idea of international law seems to be written in the scripture. To him who has, more shall be given. But to him who does not have, even the little he has shall be taken away. But I think the question which I think many people are interested in is, I think maybe starting to wind up because we have a few minutes to go. And what would be your parting shots to our audience? Like, we're talking first of all just about international law, and as you've seen, there's skepticism. It is the law. It is a law against us. As someone said when we started the conversation, someone wrote, I just failed to find the comment. He said, it is the law that the righteous cannot defend and that the wicked cannot obey. So what we Ambassador Yebare had told us international law is changing. What would you say in your parting shots? What would be your parting shots in about 2 minutes about international law?
Thank you. For me, international law remains very relevant. I have given the positives of international law that I've experienced firsthand. So the fact that there's so much chaos and disregard does not mean it is not working. It is working, the challenges, we're not hearing about the positives. For that problems, just like national law, we said there are issues. The issue is now for us to come together, especially the young generation, because you're the ones,
Alfreds.
the Alfreds. You even own us, so you are team lead of a society. So even better because you have bigger audience.
International society.
Exactement. So you have even the audience. So it is important for us to use to rethink international law right now. We have the exposure, we have the exposure to all the international law instruments. Let us rethink and be part of the conversations of reshaping international law. Ambassador, like you rightly said, Ambassador Donia said that it is changing. As it is changing, can we be part of that conversation? So for me, I think briefly and conclusion, young people, this is your opportunity to formulate international law that works for Africa, that works for you, that fits our exact context and the purpose. But don't give up on international law because it works and it is important. Yeah.
A friend of mine has sent me a message that the Canadian Prime Minister gave a speech that the rules-based order is dead. And he's saying if the Canadian Prime Minister is frustrated with international law, now for him. Yeah, but let's not go into those questions because we must not lose the main point that we are campaigning, and we don't want to annoy the Canadian Prime Minister. But finally, whenever we have a guest, an interesting new guest, and a guest doing new things, a guest telling us about things we haven't had since we wrote exams. I know a person here was telling me about Pacta Sunt Servanda. And if you don't know what that is, you are like me. Yeah. I also don't know, but someone is sending it to me here that there's something called Pacta Sunt Servanda. I think it's the sanctity of contract. What you sign, you must agree. I've been educated. But whenever we have a new guest telling us new things, fresh things, quoting for us these statistics, you've all had these statistics. In fact, actually, I must confess, I feel personally rather provoked by this discussion that 30-something% of African women have access to the internet.
T1.
So actually, when you talk about women's rights here, we have a challenge here of women's rights.
Yeah, huge.
Electricity, 40 million people have no access to electricity. People are fighting with drones, Anyway, I was going to say something, but so whenever we have a new guest, yes, maybe you first say something.
I'm so sorry. When you talked about internet, it reminds me because I think earlier on I mentioned I'm really passionate about space law because my friend Selemani, who is at ITU, introduced me to it. As we are still even talking about just basic internet, people are already fighting for space for satellite internet. And we've not even had the conversation yet about satellite. So you imagine why. You see, the future is in your hands. You guys need to really get onto the program. If not, the inequality that internet and artificial intelligence is going to drive for us is huge. We are not even ready.
With those very encouraging words, and with 3 minutes to go, can you advise our people who are listening what books you are currently reading? We always ask you to say what books, and there's a song. Now, I have a song which I would have suggested, but people are really tired of listening to my particular song, which is from Afrigo. So we want a song from you. What is the music that's making your heart beat better, and what is the book that's opening your mind deeper?
I think thank you so much for that opportunity. I have my assistant here. Maybe he'll choose. Where is he? Because there's a song we really love that is very passionate and resonates with the 6th region of Africa. But anyway, for a good read, it may not be a book, but because you talk about the challenge we have on women's rights, the advice I would give people to go and read the CEDAW Convention. Why do I say this? Because it reminds us that the full and complete development of a country, the welfare of the world, and the cause of peace require the equal participation of women and men, girls and boys at equal levels. So it's a way for people to understand what women's rights and girls' rights are all about. You then realize that you stop bashing feminists, many people bash feminists for saying, but when you have a reading of the CEDAW Convention, you realize, so these feminists make a lot of sense. Yeah. Then for that song, is it okay?
Yes.
I'll invite my assistant. Please
a-
come and choose for us the song that we are debating on.
And I think you should say hello. I think
Yeah.
this is the best assistant that has ever been on the Judicial Service
Just
conversation.
listen there, yeah.
And just
So-
tell us your name, your age, and what song. And this is the best assistant we have seen here. Actually, I think you are the assistant, Brenda. But anyhow,
My name is Emmanuel Odongo. This is my mother, and I'm acting as an assistant today.
and how old are you?
I'm 10 years old. I'm
10 years, a whole decade.
Yeah.
Yes. And you are what?
And I'm in a North Green school.
You're in the North Green School, which is very close to our hearts here at the Judicial Service Conversations, because our founder, our director, is the director of your school,
Mrs. Matovu.
Mrs. Matovu. Elena Law Matovu. We have released our secret. Is the producer of the Judicial Service
Wow,
Conversation.
that's
Hey.
amazing. Interesting.
And the song Mommy and I got
Uh-huh.
was called Buffalo Soldier.
Buffalo Soldier.
Sing the favorite line. Favorite line.
Stolen from Africa, brought to America.
So the reason why we love that song is because, you know, Africa has a sixth region, which is the Caribbean. And oftentimes the Caribbean people were taken from us because of slavery. And that is that UN has recently, UN Security Council passed a resolution in regards to naming the transatlantic slave trade as the biggest crime against humanity. So that song is befitting to highlight how important that UN resolution is. So thank you. But lastly, there's a poem by poems by the first UN global advocate called Marianne Booker Hassan. She talks about peace. She talks about women. She's powerful. I think you should host her one day. She's a power. She speaks power. She exudes power for women and girls, for
Marianne
global
who?
peace. Marianne Booker Hassan. So I'd encourage everyone to go listen to her poems and be inspired. But yeah,
Which
thank you
particular poem?
there are many. You'll be blown away. Yeah,
Okay.
but she's a Nigerian poet.
Okay.
But
So
thank you so. Thank you very much, Judicial Service.
Conversations.
The Parliament of the Bar.
Thank you, the lawyers.
Parliament.
Lawyers.
The lawyer's lawyer.
The lawyer's lawyer. Thank you so much for the opportunity to be here. It's been very enlightening to have a conversation, but also for Ambassador Adonia joining in, because Ambassador Adonia, I see how hard him and his team, PS Bajire, of course, Rotengo, Ambassador Rotengo, how everyone fights to ensure that Uganda is represented at different multilateral systems. So thank you to all of you. Passionate young generation, we rely on you because the future is in your hands. Thank you so much. Thank you, Elison.
And if you've just joined us on the Judicial Service Conversations, we are happy and proud to inform you that you are late. You have missed a powerful conversation about the future, about the past, about the law. But you're lucky if you've just joined us, because you can get this recording on. And from us to you and to everybody who has joined us, I would have made my usual long speech, but maybe I should. Thank you so much, Brenda. I think when we talk about the international legal system and how poverty, disease, and backwardness has been shortchanging this continent forever, and the inequality that's coming, and the inequality to the women of this continent. I have recently become a feminist. I am better than all these feminists here, but I will not tell you why. I will not tell you why, but they know why. But as we are entering a new interesting global age, I think it is good that we have the sort of conversations that we have on this, the Parliament of Lawyers. So if you have just joined us, we used to be called the Parliament of the Bar, but someone who is on told us here very openly that bars have many parliaments, so we should just call ourselves the Parliament of the Lawyers. So as the Parliament of the Lawyers, from us to you and everybody joining us from wherever you're joining us from north to south, from east to west, good morning, good afternoon, good evening, and good night. And we leave you with the wonderful words of Bob Marley, Buffalo Soldier.
Thank you so much.